All right, this is Dan Hunt, the Miami Shark, with a little discussion about the Florida Private Sector Whistleblower Act. If you think you're a whistleblower and you work for a private corporation, pretty simple. Here's what you need to have for your attorney and what you need to know in order to call an attorney in order to see if you have a Florida whistleblower case under the Private Sector Act. The public sector is completely different. May do a video on that later, but those are cases I don't handle. So 3 requirements under Florida Statute Section 448.102. You must threaten to disclose to an appropriate government agency under oath in writing an activity, policy, or practice of the employer that is in violation of a law, rule, or regulation. Okay. You have to put it in writing. If you don't put it in writing, you're done. You don't have a case. Emails are fine. Text messages are fine. 2, you have to provide information to or testify before an appropriate government agency, person, or entity conducting an investigation, hearing, or inquiry into an alleged violation of law, rule, or regulation by the employer. Or 3, you have to have objected to or refused to participate in any activity, policy, or practice of the employer which involves a violation of law, rule, or regulation. Now, there's been some recent case law on it. You can read the case if you want. The link is going to be below. It's on my website. But here's what you have to have, okay? You have to know when you call the attorney the law that they broke. And it's not just they're committing fraud or they lied. You have to be able to point to the law. Say, Florida statute number, rule and regulation number, OSHA regulation number. This is what was violated. It's not just, I think they violated the law. I believe they violated the law. You have to know for sure that they're violating the law. Okay, and you have to be able to tell the attorney exactly what law they're violating by citing the law, not by saying a vague term in reference to a law you think exists. Look it up, know it before you call. You give a number of the statute, you give a number of the regulation. Don't expect a lawyer to sit there on the phone with you, spending a half an hour of their time just to try to figure out whether there actually was a law that exists. Because when you said to your employer you're breaking the law, or you wrote to your employer you're breaking the law, you have to have said what that law was. Otherwise, you don't win on the whistleblower statute. It's not easy. So not only do you have to refuse to participate or threaten to report them, it's always better if you actually report them in writing, but you have to say in your writing, you're violating this law and give the law. You might not have to give the number to them, but you have to tell them what the law is that they're violating, and you have to refuse to participate. On top of all of that, they have to have retaliated against you for you to have any types of damages. They have to have demoted you, fired you, taken away your hours, done something to cause you actual damages. If you don't have damages, you're missing one of the main elements of filing one of these cases. And if there's no money in it for you, then there's no money in it for an attorney. An attorney won't take it on a contingency basis. Attorneys will always take your case if it has legs, if you pay them. But remember, it costs a lot to prosecute these cases. Attorneys charge anywhere from $300 to $1,200 an hour. Some attorneys charge $2,000 an hour, and you have to pay for costs. You know, it costs $500 to file the complaint. It costs a couple $100 to serve it on the defendant. It costs money for depositions, mediations, etc. If you don't have a case that is worth any significant amount of money because you weren't terminated and you don't have lost wages, then you're looking for declaratory relief, basically for a judge to say, yeah, they violated the law, you're a whistleblower. But remember, this is a retaliation statute. So they have to have done something to harm your financial well-being. That being said, this isn't about individual employees breaking the law. You know, my supervisor or coworkers are using drugs on the site. It has to be a law that was broken by your employer, that you complained to your employer about in writing, and it has to be a law that they're breaking in order for them to make more money, to make it easier to run the company, to make it easier for them to, you know, skirt the rules so they can save some money somewhere. You got to be able to show that. If you got all of those things, then you might have a whistleblower case. If you want a more detailed explanation of more facts and scenarios and explanations of the whistleblower statute and what's involved, you can listen to my paid video below, and the link is below.